Commutation of pension, a debate that affects every retiree. Restoration after 15 long years. Pensioners raise their voice against the stand of the State Bank of India.
Telangana rules prescribe restoration after 15 years linked to government budgetary grants. Pensioners argue SBI has a distinct framework, fully funded internally, making the analogy irrelevant. Telangana state employees follow government commutation rules with a higher factor and budgetary dependency. SBI employees follow a separate statutory framework with lower factors, internal funding, and yet the same 15-year restoration period. Commutation factors differed for civilians and defense personnel. In the 1986 Common Cause judgment, the Supreme Court applied the principle of years of purchase plus 2 years and fixed a uniform 15-year restoration period. Pensioners maintain the Common Cause judgment is misplaced for SBI. They highlight evolving actuarial standards and demographic realities, stressing that the outdated 15-year principle causes injustice today. Courts have upheld the 15-year rule in cases like Forum of Retired IPS Officers, Sheila Devi and others. These decisions strengthen reliance on the 15-year restoration principle. The Sheila Devi case dealt with Punjab government employees, while SBI pensioners come under separate statutory regulations. Government commutation factors are transparent and budget-funded, whereas SBI's factors lack disclosure and rely on the bank's own resources. In the Balwinder Singh case, the court extended the Sheila Devi framework to SBI pensioners, opting for an expert committee review, keeping the issue under policy consideration. Pensioners highlight disparities. In the Sheila Devi case, only 2 SBI petitioners were included, less than 0.07% of the total. No specific arguments for SBI retirees were independently considered. Punjab and Haryana High Court upheld the 15-year rule despite changes in interest and life expectancy. The 5th Pay Commission had suggested 12 years, but the government retained 15 years. Courts held that pension commutation is a policy matter, not arbitrary, and upheld the 15-year restoration rule. Though recovery may occur earlier, the risk factor justifies 15 years. Commutation being voluntary, petitioners who accepted the terms cannot now challenge them. SBI pensions operate under separate statutory rules and require independent appraisal, so other cases can't be applied directly. Also, the so-called voluntary option isn't truly free, since pension is a statutory right and must meet equality principles. Voluntariness is subject to judicial review, and SBI itself admitted its commutation factors were arbitrarily reduced from government tables. Pension is a statutory right, yet retirees lack bargaining power and are compelled to accept unfair terms. SBI itself acknowledged the hardships of its officers. The commuted amount is already recovered in about 7 years, yet deductions continue for 15, leading to unjust over-recovery. This arbitrariness clearly warrants judicial review. Pay Commission advice is not binding. Applying it to SBI without fresh actuarial review is arbitrary, as life expectancy and rates have changed. Excess deductions are a recurring grievance. SBI's own records show the pension fund is financially strong, making the risk factor argument weak. Yet a rigid 15-year rule persists, mismatched with this capacity. Bank argues that the commutation offers pensioners key benefits: fixed 15-year recovery, no recovery after death, a lump sum for investment, and income tax exemption. Pensioners argue that these so-called benefits are assumptions, not consistent with SBI rules, real experiences, or tax laws. The 15-year recovery rule is arbitrary, outdated, and unjustified, as restoration depends on dynamic actuarial factors like interest rates, mortality, and life expectancy. Pensioners contend that the so-called advantages are misleading. The 15-year rule is not actuarial, non-recovery after death is standard everywhere, lump sum returns are speculative, and tax relief is a general law, not a scheme benefit. The 15-year recovery rule is arbitrary, outdated, and unjustified, as restoration depends on dynamic actuarial factors like interest rates, mortality, and life expectancy. With interest rates falling sharply over the years, there's strong justification to revise commutation factors and reassess the 15-year recovery rule. Mortality tables are revised periodically to reflect changing life expectancy, ensuring pension calculations match current demographic trends. Mortality rates have steadily declined, showing improved survival and longer life expectancy across ages 60 to 74. With better healthcare and longevity, cases of non-recovery are rare. By 7 years, the commuted sum is effectively repaid. The Finance Ministry rejects pension reforms, citing increased life expectancy as a financial risk. Yet, it uses the outdated 57-year life expectancy to justify the 15-year restoration rule. This is a direct contradiction in policy. SBI has kept commutation factors unchanged since 1994, ignoring periodic revision. Pensioners repay commuted amounts within 7 years, but deductions continue up to 15 years, causing excess recovery and unfairness. SBI still uses commutation factors from 1971, advanced arbitrarily by 10 years, unchanged for 54 years, ignoring present mortality and interest rate trends. The Second National Judicial Pay Commission recommended restoring commuted pension in 12 years, based on detailed study, including IPS officer's case. Kerala High Court held pension as a constitutional right. Since recovery happens in 11-12 years, the outdated 15-year rule is unjust. The court directed re-evaluation of the period. Deductions beyond recovery are unjust and against the model employer principle. The 15-year rule is outdated. Restoration must be fair, updated, and constitutionally valid. No pension scheme recovers from family after death. Actuarial norms and accounting standards already factor this in. Further deduction is excess and unfair. Employee benefit obligations are valued through actuarial assumptions, considering mortality, survival, and employee turnover. Pension liability ends with the member's death, while family pension is treated as a separate benefit. The pension fund is self-sufficient and actuarially secured, making excess recovery unjustified. The bank, as fiduciary, must act transparently and fairly. Continued deductions without disclosing the actuarial basis breach that trust. Family pension is much lower than regular pension, reducing fund liability. Hence, non-recovery of commutation after death causes no financial loss. In fact, it leads to savings for the bank. Pensioners commute not for investment, but to meet urgent needs like deaths, healthcare, and family expenses. The lump sum is a lifeline, not surplus capital for risky investments. Expecting retirees to invest lump sums and earn high returns is unrealistic. Inflation, market risks, and medical costs erode savings. On the argument of tax exemption on commuted pension, the pensioners' contention is that such exemption flows from income tax law, applies to all pensioners, and cannot be used to justify extending recovery under the pension scheme. Tax exemption cannot justify prolonged recovery, as it mixes tax with pension policy. Nor does it make the exchange fair, since inflation erodes value and returns are taxable. The tax-free status of the commuted amount does not justify a recovery system that deducts far more than was paid. Many welfare benefits are tax-exempt. This does not shield an unfair policy from scrutiny. Commutation is a fair exchange, not a benefit, but recovering more than was given makes it unfair. The commuted pension is not an extra benefit. It is simply an advance payment of one's own future pension converted to a lump sum. The tax exemption is a general benefit, not a justification for an unfair pension cut. The right to full pension cannot be reduced based on a separate tax law. None of the purported advantages hold up under the actual SBI pension scheme rules. Employees opted for commutation knowingly. They cannot challenge the recovery rules after such a long time. Calling commutation a welfare measure is illogical. The government recovers far more than it gave, making it a financial transaction, not welfare. Commutation is a statutory right, not welfare. It is deferred wages, paid early. Calling it welfare mischaracterizes this enforceable legal right. Commutation is not a gift. It is an interest-free advance of our own deferred wages, recovered from our pension. It is an earned right, not charity. Courts rule commutation is a statutory right, not welfare. It is deferred wages. Financial concerns cannot override fairness. The recovery must be equitable, not enriching the employer unjustly. Recovering more than was given is exploitation, not welfare. This policy violates constitutional rights to equality, dignity, and property, and is against public policy. SBI failed to disclose the actuarial basis for the commutation factor. This breaches its duty of good faith and transparency, voiding any informed consent. The choice to commute was not truly voluntary. Critical details were hidden, making the consent invalid under contract law. The bank breached its fiduciary duty by failing to act transparently. With pensioners having no bargaining power, the so-called voluntary choice was neither fair nor genuine. The cause of action is continuing as excess recovery goes on even after full repayment, keeping the grievance alive. Pension is social security, so contracts must favor pensioners over unfair recovery. Pensioners question unjust recovery and denial of restoration, not commutation. Any clause defeating pension's purpose as social security is void, violating constitutional rights. Commutation is a statutory entitlement, and excess recovery amounts to unjust enrichment against fairness and transparency. Courts show restraint in pension and commutation matters, treating them as policy issues. The Supreme Court upheld the 15-year period, noting lump sum benefits, while stressing that only grave injustice justifies intervention. The IPS officer's case cannot apply to SBI pensions, as the SBI scheme is statutory and funded separately. It is self-sufficient and distinct. Recovery continues for 15 years, despite the commuted amount being fully recovered in less than 7 years, with no periodic review of commutation factors. SBI's 15-year recovery rule is arbitrary and disproportionate. The IPS officer's case never examined over-recovery, making its reliance misplaced. Also, 7th CPC recommendations apply only to government staff and are not binding on SBI pensioners. The relief sought is limited. Fix restoration based on actual recovery and review the period actuarially with refund of excess. SBI itself admits pensions are a statutory right, the fund is strong, and recovery ends in under 7 years. Pensioners argue the 15-year rule causes over-recovery, ignores actuarial realities, and unfairly cross-subsidizes beyond actual need. SBI's case is distinct. Its fund is stronger, recovery happens in under 7 years, and CPC or SC rulings for central schemes shouldn't apply. Petitioners stress SBI's self-funded pension makes CPC logic irrelevant, recovery is transparent, and they only seek to stop over-recovery or allow an SBI-specific actuarial review. Judicial review allows interference when policy is arbitrary or irrational. Pensioners argue SBI's 15-year rule lacks actuarial basis, ignores its strong fund and early recovery, and wrongly copies central policies without SBI-specific validation. SBI's pension scheme is self-funded, recovers commuted value in about 7 years, and has a stronger corpus. So applying the 15-year rule from state-funded schemes is unjustified and irrelevant here.
The 15-year rule is justified as a policy choice with no restriction on recovery. While pensioners counter that, SBI itself confirmed no interest is charged, making over-recovery unjustified.
Despite SBI's claim of no interest, 15-year recovery exceeds the lump sum, implying hidden interest. Since pensions cannot be unfairly reduced, judicial intervention is warranted. In conclusion, the RTI reply confirms excess recovery as implicit interest, and SBI's own no interest admission makes the recovery arbitrary and unjust. Pension is treated as a welfare measure by policymakers, but pensioners contend it is a deferred wage and a statutory right, not charity. Recovery beyond the actual commuted amount is unjust and amounts to undue enrichment. Fiscal policy cannot override statutory rights, and courts requested to prevent arbitrary recovery. Extending recovery beyond the actuarial repayment period leads to unjust enrichment and violates constitutional rights, warranting judicial intervention. The 15-year rule replaced lifelong recovery, but pensioners argue it's still disproportionate since actual recovery finishes in under 7 years. Uniform adoption doesn't prove fairness. The 15-year rule lacks actuarial basis, leads to unjust enrichment, and violates constitutional rights, warranting judicial intervention. Unlike government schemes, SBI's pension is contributory and actuarially managed. Yet no evidence supports the 15-year rule. Such an arbitrary system takes more than what's fair, breaching Articles 14 and 300A. SBI's own letter shows commutation factors were fixed arbitrarily without actuarial basis, making the 15-year rule unjust, irrational, and liable to be struck down. The Eighth Pay Commission's review proves the 15-year rule isn't settled, supports claims of arbitrariness, and strengthens the case for judicial reconsideration. The 15-year rule lacks fairness, actuarial basis, and legal support. Its continuation causes unjust enrichment and violates pensioners' rights, warranting judicial strikedown.
Thank you for watching this presentation. If you found this information helpful, please like, share, and subscribe to my channel for more updates on such important legal developments. I sincerely thank everyone who has subscribed and those who will be subscribing in the future.